Bonjour, Gima ou Gima Nusnakat, Kiatsal Indonji, Gishkamisi, Mazane Dodem, Chimiquet, Chinishnala, Chimiquet, Kinawea. Good evening, everybody from Gull Bay. I want to wish everybody a warm welcome tonight. We have our legal counsel, Robert James, joining us. If you have any questions pertaining to the land claim, you could ask them and we will try to answer them. We have 200 people that are registered for this, so we'll try to get to the land claims questions as soon as possible. I just want to introduce our lawyer, Mr. Robert James. I met Robert when I was in Toronto. Robert was at a Prospector Development Association of Canada meeting, and he was on a panel of renowned lawyers from across Canada. And I asked the panel a specific question, and I felt that Robert gave the best answer. And I approached Robert after the panel session, and I told him about our situation in Gull Bay and our land claim. And Robert was willing to look into our case. And after a quick discussion, Robert came on board and joined Gull Bay. And just for your information, that Robert is one of the best Aboriginal and treaty rights lawyers in Canada. He works on the law firm of JFK Law out of Victoria, Vancouver, and they're opening up a Toronto office. There is a national ranking of lawyers worldwide, and Mr. James, for the use of his Core Law Corporation is ranked #1 in Canada. And he is one of the top Aboriginal law practitioners in Canada, and he is well recognized by his peers and internationally as a very, very good Aboriginal treaty rights lawyer. So without further ado, maybe I'll let Robert introduce himself, and then if there's any questions for Robert or myself, I'll be willing to answer them. And I want to thank you again, and thank you, Robert. You have the floor, sir.
Thank you very much, Chief. Thank you very much, everybody, for attending. I can see there's 100 of you out there, so I know there's a great deal of interest in this. So Chief King has told you a little bit about me. By background, I've been practicing in the area of Aboriginal law for close to 25 years now. I've done a number of cases around involving treaty rights, Aboriginal title claims, Aboriginal rights claims, cases involving things like the Northern Gateway pipeline. So I've seen a wide variety of cases, and this has been one of the more challenging and difficult cases, but it looks like we're reaching a place where there's a very good outcome in front of us. So let me just tell you a little bit about the background of the case so you understand what it's about, and then hopefully give you a sense of where we are right now. And I just want to highlight before we get into any of this, is that we're at a stage right now where we're still negotiating with the government. We've reached, with the government lawyers, an agreement at the sort of the lowest level about, look, here's the understanding of what we think will work. We'll all support this. The government is inside seeking their approvals of this. But one thing that's very clear is there isn't a settlement yet, and any settlement will have to be first approved by the council, and then it's going to have to be approved by the community. It's very clear that given the size of the settlement that we're talking about, the importance of the settlement, that the community has to be directly involved in approving this. And so this is the first step in helping the community learn about what's being discussed, a chance to ask some questions, give some feedback, and then, but there will be a lot more time, assuming that we do reach an agreement that looks like this, to talk about this further. There'll be further community meetings, and there'll be lots more information. So this is a chance to have an early discussion to make sure that the community knows what's coming up and can have a well-informed discussion about this if we get into a real approval process.
Robert, just for the information before you start, that on the right-hand side of the dashboard is where you can type your questions relating to the land claim. So on the right-hand side of your dashboard, that's where you can type in your questions. So, okay, sorry about that, Robert. Go ahead.
So the So back when the treaty was signed in 1850, um, Chief Mishimakwa, was identified as being entitled to a reserve. And what the treaty document says, the piece of paper, is it was a reserve that was to be 4 miles by 4 miles at the mouth of the Gull River. And what happened was that that's what eventually the surveyors, not until 1886, went out to survey. But what we know from the other documents at the time, from the other reserves that were being set up, from what the translator who actually worked for the government said, was that at that time, nobody on the Anishinaabe side of things thought of things in miles. They thought in things in terms of a day's walk or a longer distance, but the main unit of measurement that they'd always worked with was something called a French league. And a French league, and people, the historians disagree about exactly how long it was, but it's definitely longer than a mile. It's likely greater than 2 miles, and probably somewhere up to close to 3 miles long. So instead of being a 4 mile by 4 mile reserve, it should have been a much larger reserve, that is 4 leagues by 4 leagues. And that would really mean at the high end that it would be up to 12 miles by 12 miles, which is close to 144 square miles instead of the 16 square miles that you got. That's at the high end. Now, of course, what happened was that close to 20 years ago, an earlier council went to Canada, Ontario, and started what's called a specific claims. That's a type of negotiation where they tried to get the governments to agree that the band was entitled to a larger reserve. And after several years of this, the governments refused to proceed with those negotiations. The government denied the claim, essentially saying that Gull Bay couldn't prove that it was entitled to the reserve, and that maybe it was Red Rock and maybe it was somebody else, and all these sorts of things. So, the earlier council and their lawyers, it was left at that. And then, as Chief King was saying, Chief King, on behalf of the council, present council, came to us and said, we'd like to look at this. Is there something we can do about this? And we looked at it, and when you look at the documents, you look at the history, there's really a good case to be made that you are entitled to a much bigger reserve than the one that you got. And there were really 2 choices for us. One choice is we could go back into the government negotiation process and maybe go to the specific claims process, but that would only get you money. That wouldn't get you land. Or we could take the governments to court, where we could pursue both money and land. And Chief King and the council were clear that the nation really wanted to have its land. It was important to have land, and that this wasn't just about money. So they told us to start a court case, and so we did start a court case. We sued Ontario and the federal government, and we started out on what has been a very lengthy path. A judge, a fellow named Justice Lederer, was appointed to manage the case. The governments again raised this argument that maybe other bands were entitled to the reserve or entitled to a share of the reserve. So there was an ongoing battle. Eventually, some of the other bands started their own claims, and they made it clear that they weren't claiming the Gull Bay Reserve. They claimed that they were entitled to their own reserves. And eventually what happened was that the governments were really digging in. They were dragging this process out. We went through the whole process of getting expert reports and pulling together the documents and reviewing the government's expert reports. We even went through a process of having the experts meet. We went to court a number of times to sort of fight over procedural matters. But eventually we pressed the judge to consider actually having what's called a mediation. So in other words, a mediation is where the judge takes all of the parties together, and then in this case with the judge sitting there, the judge essentially tries to get people to be reasonable and come to a reasonable settlement. And the governments hate mediations because in ordinary negotiations, they can just sit there and say no, and there's no one to tell them that they're being unreasonable. In this case, with a mediation, there was actually a judge sitting there who could push them to be reasonable, to bring forward proposals, to actually try to resolve things. So for the better part of the last year, we've been involved in a series of these mediations with Justice Lederer, and they were very intense. There were a number of expert reports prepared for these where we looked back at the population. We talked about ways in which we could come up with a fair approach to all of the nations. We talked about what was being done in other claims. We talked about the risks of the case and different views about what a league was. And at one point, we actually got to the point where we felt the government was being unreasonable, so we actually walked away from the table. The governments were keen to pick up the negotiations, so we actually had some meetings then in the summer without Justice Lederer there. And based upon those discussions, we reached this framework for an agreement that everybody is now talking about with their bosses. We hope we'd be further along. Of course, there is that little detail of the election that Mr. Trudeau called. So that has delayed things somewhat. But we're now in a position to talk to you about what is likely to be on the table. And I do want to make it clear that this has to be approved by Treasury Board and has to be approved by Cabinet, and that process is underway. But we're quite confident that this is going to come forward as a proposal. So there's a couple of things that we're looking at here. There's the land. So how much land should you get? There is the cash. How much cash should you get to compensate you for the fact that you didn't have the land? And then there's the cash that's needed to cover things like your legal expenses, your past expenses. Then there are going to be costs in getting land. So for example, land has to be surveyed and in some cases there might be some remediation that has to be done. And then of course there's going to be a process to get to the point where this actually becomes reserve land. So there's going to be costs associated with that. So in terms of these different buckets, here's where things stand right now. So we've gotten to the provincial government, the federal government to agree that that each of the nations who are involved at this point in time, including Gull Bay, should end up with a total. Each of them have a total of 110 square miles. So that means that Gull Bay should be getting an additional 94 square miles of land, increasing your reserve land from 16 square miles to 110 square miles. In addition to that, to compensate you for, sorry, let me just talk about that number for a second. So you remember that I said, look, there's a fight over how big a league is. So I just want to give you a sense of where this ends up. Is that, even if we won, there'd still be a fight over how long should a league be. So it could be as little as 2 or it could be as high as 3. What we're talking about here is 2.85. So we're getting pretty close to the best case scenario for what a league was. And I will just highlight that there's one nasty historical fact that we had to deal with, which was that when the surveyors came in 1886, Chief Winjab at that time, he would have been happy with a 2x2 reserve, and he signed off on a 4x4 reserve. And so 4 mile by 4 mile reserve. So in fact, there's some danger that the judge might have said that Chief Winjab, agreed to a smaller reserve, and also that the judge might say that it would have been only a 2 mile league. But the bottom line is that essentially we're working here with a league that's 2.85 miles, which is really a good result. In terms of the cash compensation, so this represents, according to what courts say, the money that you should have gotten if it weren't for the fact that the land wasn't given to you. And so, it's a good question of how much that would be, right? Because, you're in a remote area. It's not like you're in downtown Vancouver. And so there's not a lot of, towns being built, rental accommodations, buildings, things like that. Instead, the main activity is forestry. But what the government agreed to do was to essentially work out an approach to compensation that was tied to the idea that your land could have been rented every year for some amount of money based on its value. And then from 1850 to the present, figuring out what that was worth, giving a certain amount of compound interest and a certain amount of ordinary interest, and adjusting for how the dollar has changed in value over these years. And based on that, what Canada is proposing is an amount of $125.88 million per First Nation. So for Gull Bay, they're proposing $125.88 million as compensation for lost use. And I have to say, I'm a bit surprised that they did that, because they haven't discounted it for the fact that you have 16 square miles already. So, you know, that's again, in my view, a very good result. And in reaching that result, they used land values down near Lake Superior, closer to Batchewana, which are probably higher than land values near the north part of Lake Nipigon. In addition to that, the federal government is proposing an extra $1.75 million to essentially compensate for expenses that were incurred in getting here, which would include your lawyer's expenses and your expert's expenses. So the total amount then is $1.2763 million. They're not going to break it down in the deal. They'll just say, here's this much money to cover everything. In addition to that, they're willing to set up a table to deal with the ongoing issues of negotiating about which land you're going to get. You know, for example, whether or not parks should be taken off it, how the forestry licenses should be gotten rid of, whether or not there's any contamination issues, how it becomes reserve land. So they're willing to set up a table to cover that and to fund that table to cover your legal and expert and other expenses. And in addition to this, the government of Canada has indicated that it's also willing to set up a table to have a recognition of rights and self-government negotiations if you want to have that as well. And then in addition to that amount, the government is proposing, and this amount is still being negotiated, but an amount that's equal to at least 10% of the current market value of the land, to cover things like surveying and any environmental site assessment. And that hasn't been figured out yet, but that's at least $4.4 million in addition to cover those kind of costs. And we're still having ongoing costs negotiation with the government of Canada to make sure that all the surveying gets done without further costs to Gull Bay. Because as you can imagine, surveying a reserve that large is really going to be a substantial project and cost a lot of money. And then the ultimate goal is that this then will become reserve land. So this is not land that you're going to have to hold as fee simple land. This will actually become reserve land and will be yours to deal with as you want to going forward. So you will be able to, you'll get the benefit of any forestry there. If you want to develop the land, you can develop the land. If there's any quarries, gravel removal, anything like that, you get the benefit of that. So it's a resource that you will have indefinitely into the future to use for the development and support of your community. So, of course, all of this will have to come back to the community for further discussion and for a community vote. But that is essentially what's on the table and being discussed right now. And unless Chief, I guess I would like to just talk to you a little bit more about why I think at least this is a good deal. So first of all, one huge advantage of an agreement as opposed to going to court is that it saves you time and money. The reality is this case, if it goes to trial, will probably take another 3 to 5 years to completely go to trial. I hate to say it, but lawyers' fees and expert fees are not cheap. So the band would have to incur the ongoing costs of this. And then, of course, the second thing that goes with this is that there's no guarantees at the end. Anybody who goes into a court case knows that even if you have a strong case of winning, there's always some chance that you will lose. And there are some historical issues, as I was saying, which make this not a slam dunk case. It would be a real fight. And plus there'd be a real fight over exactly how much land you get, even if you do win. So, and then of course there can be appeals. which are more costs and more delay and more risk. And also what goes with this too is that there is a real issue in this case about how you should calculate what the loss of use be. I'm sure that the government of Canada and the government of Ontario are going to say, well, look, these lands would never have been used, they would have never been rented out, they would have never been developed. There's at most some compensation for some trees being taken. It should be far less than the amount of money that's being offered. And there are judges out there who might accept that. This is going to make it certain that you're going to get compensation for the past loss and not just get land. And I think in the end, there's a lot to be said for an agreement that's reached through negotiations, where it's your nation that's in charge of the negotiations and is making a decision, rather than leaving your fate in the hands of a judge. While I love court, it still means that it's not something that you control that's really controlling the outcome here. And all of this, of course, is being done without compromising your other claims. Your flooding claim is still being negotiated. We're still working on looking at the road claim, and the annuities claim is still outstanding. And all of those claims are not part of this. You still have the right to advance those claims. There's still negotiations going on about those claims. So, this is a very discrete settlement of one historic wrong, which was the failure to set up a reserve for you in the right size at the right time. So I think I will stop talking now and see if the chief wants anything to add, or if there's any questions anybody has.
Robert, we have some questions. We'll go one question at a time. The first question is, can council make the decision about how the settlement money is spent or divided?
So the question of how the settlement money is going to be dealt with is at least in the eyes of this council, as I've understand, that it's going to be something that's going to be part of the discussion between the council and the community, and will actually, the community's views on this will be solicited as a part of the approval of the settlement. So the answer to your question is the chief and council actually, under the Indian Act, can make the decision. As I understand it, this chief and council has decided that it's going to get the community's views as to how the money should be divided up, whether it should be individuals get a certain amount, or how much should be dedicated to community infrastructure, how much might be saved. And that's going to be part of the process.
And I just want to further respond to that, Robert, that it is our desire that we would follow the other processes that we followed in the past, in which we will have community consultations, and it'll be up to the community to decide what options they want. Second question, Robert, we have here is, will all members be treated equally? So much is being talked about right now, which makes those of us who don't have the privilege to live on a reserve like we are less than. Will on and off reserve members get to vote and get treated equally? So
the law is clear that when it comes to voting and other decisions, let's start with voting. The law is really clear that the chief and council and the band can't make a difference between on-reserve members and off-reserve members. Is that everyone is entitled to vote in the referendum. Everybody will get an information package. Everybody will be allowed to attend the information sessions, and everyone will have a say in how the voting goes. As a general rule, the band council can't discriminate between people on the basis of being on or off reserve. So, I mean, I can't tell you what, obviously the chief and council or the committee may want to do, but what I can tell you, the law doesn't allow discrimination on the basis of being on or off reserve. To the extent that there's things that get built on reserve, those are for the benefit of the whole community, and people will come and go from the reserve. But there's a basic law that prevents discrimination.
Robert, there's another question. It's for you. The timing of the settlement seems convenient. Given that there is an election coming, can the lawyer tell us why this is happening now?
Well, the main reason it's happening now is because of the fact that it has taken this long to get the government of Canada and the government of Ontario to the table. The government of Ontario made its proposals about land in really quite late in August. Like they really started discussing it and making their proposals. Like we were going back and forth about cash with the government of Canada for a very long time. The government of Canada took very stubborn positions. The government of Ontario started talking about land at a quite early stage. We were pressing, to be clear about it, we were pressing for more negotiations and earlier negotiations, hoping that all of this would be done long before this election and long before the federal election. We were very worried, in fact, about the federal election because of the fact that if the Conservatives won, they may not have been behind this agreement. So it's just that it took that long to get the governments to come to the table and to make offers that were acceptable. And remember that we had to, it wasn't just us, it's like all of the nations involved in the negotiations, who would include AZA, White Sand, Red Rock. We all had to get on the same page. And so, you know, it was a long and extended negotiation. The pandemic didn't help. We had to do all of our negotiations by Zoom, which make negotiations much harder. And the government, of course, had to go back on many occasions to talk to their superiors to get authorizations to get these proposals. So, you know, my own wish was that we, and I know Chief King was grinding me to get this settled earlier. I mean, ideally, we wanted to have this up in cabinet and decided long before the federal election, but we just couldn't get the governments to move fast enough. And I will say, we're also, just let me finish this up. The other thing is we were also all convinced that we couldn't get the governments to put another nickel on the table. That's the other thing, is that we could have settled earlier if we caved in. But a big part of this was actually getting the government up to the numbers that they were looking at, because the early proposals being made by the government were a lot fewer miles and a lot less money.
Will this settlement extinguish all future land claims?
No. As I was saying, is that this just deals with the size of the reserve. It doesn't deal with the flooding claims. It doesn't deal with the annuities claim. It doesn't deal with the road claims. If there's any other specific claims out there, then they're preserved. If there's claims that come out of your treaty rights, off reserve, like consultation claims, you know, if somebody's building a mine and it's going to interfere with your treaty rights, all of that is still on the table. So this is not changing your fundamental rights to be consulted or to be compensated for any losses of your lands.
Okay. Robert, could you name all of the communities involved in this land claim? And are they all settling for the same amount, and why, I guess?
Yeah, so I just listed off the nations. So Gull Bay, White Sand, Red Rock, and AZA are involved. They are all settling, everybody's settling for the same amount. And the reasons for that, there's a simple reason and there's a complicated reason. The simple reason is that the best way for the government to keep these settlements from happening is to have the First Nations fight amongst themselves over who's entitled to more, who's entitled to less. I mean, the negotiations over at Pick River and those nations have gone on for years and years longer, and will probably go on for years and years longer more without the government ever having to pay, because everybody's fighting over how to share. What makes it complicated in this case is that, you know, there's all kinds of ways to say, well, you know, look, Gull Bay got land early, somebody else got land in these years. You know, somebody will say Gull Bay got the benefit of the tax exemption and federal spending over certain years. The people at I guess AZA say, well, you know, we didn't even get a reserve, and so we didn't get any of the benefits of federal spending. So there's all kinds of arguments you can make all over the map. And then the other problem is that you have to track populations over the years, which is very, very difficult. So the nation's chiefs and negotiating teams looked at each other and essentially said that it's better to do a unified front against the government to work together to make sure that this settlement happens, that we don't give the government an excuse to drag it out, and we'll share the pie equally, but then use our unified front to make the pie bigger, which is basically what we did.
Okay. Are the legal costs a percentage of our settlement, or are we being charged hourly?
So I've been charging you hourly. I usually don't do percentages because the problem is that number one is the percentages tend to be too big and it looks a bit unfair. So instead, I've been charging hourly, and I don't know the exact amount I've charged, but it's less than the amount that the government is adding on to cover past costs.
Robert, I guess the second question was, can we estimate what the legal costs are right now?
There's somewhat around, I think, probably I don't know what the expert fees are, but there's somewhere around $1.5 million, I think would be approximately where they are, but I'd have to go back and double check.
Let's keep in mind though, folks, that we started off with a zero deal. The government said you don't have a case, you don't have a claim. We took the gamble and we said that we thought we had a very good case, and that's why we hired Robert. Council made a conscious decision to pay his legal fees, and the result is we have 110 square miles plus 125 million plus all his legal fees and above. So I think it was worth the risk, considering that we were told we didn't have a case to start with. So I hope that clarifies that.
Well, actually, and maybe I'll just add a little bit more so people understand. So
Okay.
if you went to trial and won, you'd only get paid about 30 to 40% of your legal fees, and the rest you'd have to bear yourself. And on a contingency fee, so that's a percentage, like the courts approve percentages, somewhere between 5 and 10%. So that would be a substantially larger number. So we've done our best to keep the costs in control. I know it seems like a lot of money, but as the chief says, we hope it's because of the fact that it was for a good return.
This is a question for both myself and Robert. I'll let Robert go first. Rod Wigwas told us there was no claim. How is this coming about now, and how much longer is negotiations happening?
Clearly the government won't settle cases unless they form the opinion inside that there's a claim that creates a real risk. So the fact that there's a settlement means that there clearly was a claim, that the government really decided there was a risk, and that the risk justified this settlement, because they have to justify it to the public. So that's because when you think about it, over 4 nations, you're looking at close to, over $500 million, plus probably another several $100 million of land. So the government has to justify this to the public, and they could only justify it because there is a claim. So I can't say why Mr. Wigwas said what he did, but I clearly disagree with it, and clearly the government disagrees with it. In terms of the approval process, the government has already started the approval process. We can't control that, but my expectation is that we can look at a formal proposal from the government that's been approved. I hope, and I'm not promising you this because it's not in my control, but I'm hoping December or early in the new year. And I don't think there'll be that much negotiation to get the settlement to the point where it actually goes and and goes for community approval. Once there's community approval, and that takes a couple of months because there have to be information sessions, the agreement has to be distributed to everybody, there has to be a chance to ask questions, then there has to be a referendum. So once there's a community approval, generally speaking, the money will flow some months after that. Usually it takes usually 60 to 120 days for the government to make the money flow. The land is going to take a bit longer because the land, we have to figure out what the land is we want. We have to get rid of any parks on it or anything like that. There's a bit of a process around that. The government will be paying the legal fees during that part of the process. It has to be surveyed, et cetera. So that's probably going to take some years. But the actual negotiations, is that I'm hopeful they'll be done early in the new year.
Robert, this sort of goes to the same question. Does the community get to decide how and where the expansion of land is located?
So that's something that has to be negotiated. That has to be worked out between the government and the First Nation, and that's going to take some time. I'm sure that the chief and council will be doing a community process to make sure that the community has a say on the different options that are being considered. It's a lot easier in your area because of the fact that, you know, it's not like you're in the middle of Lake Nipigon, because the government won't transfer private lands and things like that. So, you know, the idea would be that the lands would be in your territory, preferably closer to your reserves, but the exact details have to be worked out, and I'm sure there'll be community consultation about this.
This question is for me. It says, how many Gull Bay members are there right now to receive benefits from this claim? Right now, we currently have 1,474 members, but they must be registered at the time of the ratification vote. So they have to be on the Indian Affairs list to be eligible to receive any benefits. And so that's the number, 1,474. Question is, how will trap lines be affected if Gull Bay decides to take land in the trap line locations?
I don't think that will have a huge effect one way or the other. So,
Robert, just to answer that question, Gull Bay does have a big community trap line as it is, and the trap line would probably extend already far beyond this negotiated settlement. So we do have a Gull Bay community trap line already, a big community trap line. The question is, another question we have here, can the settlement amount that eligible members be garnished? Can they be garnished?
that's a tricky question. So the answer. So look, I can't give a specific answer to that because, but generally speaking, payments from the Crown can't be garnished. And then for members who live on reserve and have a bank on reserve, they can usually make sure that their money is protected by the Indian Act. Once the government has paid the money, though, if you have a person who's a status Indian living off reserve, and if they put the money in an off reserve bank, then it is possible to go after it. But so I can't give you a general answer for that. It really depends on each individual circumstances. But the initial payment, generally the rule is, and you know, there may be some exceptions for, I don't think there actually are exceptions to this. The general rule is that payments from the government to the individual can't be garnished. But then once the individual has it in the bank, you better make sure that the bank is on reserve and things like that.
Has the idea of not taking any money been considered with the idea of taking all land? So,
yeah, so the government, we talked about that. We actually talked about whether we could increase the amount of land by trading off money. And the trick is the land is coming from Ontario and the money is coming from Canada. And basically Ontario is not willing to do that kind of trade because we were trying to push the amount of land up to the full 144, but we we would have to go to court and win everything to really push it past this. So that kind of trade-off would have probably ended the negotiation.
There's a question for myself. It said if negotiations are finished in December and January, how long until the ratification and potential payout happens? Basically, we have a 65-day minimum period, and it'll describe basically how it will be paid out. So that'll be about almost a 2 months process. So if negotiations are concluded in December or early January, we're looking at a payout in maybe February or March.
Well, sorry. I'm gonna pause for a second. I actually think
Okay.
you should allow a bit more time than that, because you have to allow time for the ratification process.
Well, that is part of the ratification process, yeah. Robert.
And then once it's approved, yeah, typically the government takes 2 to 3 months to flow the money.
It all depends. Sometimes they're quicker.
Sometimes they're quicker, but I don't want to get people's hopes up too high. Yeah, let's hope for an early Christmas, but I won't promise it.
Yeah. Okay. Does the lawyer intend to establish a trust for the children? Robert, this is your question.
So this depends on how you decide to pay it out. If you decide to make payouts to every member, typically what happens is that money for anybody under 18 is held in trust, and then when they get to the age of majority, it usually gets paid out with whatever interest has accrued.
Robert, we set up a trust for the OPG settlement for the children, and also under our timber claim, we would follow the same process where we'd set up a trust agreement in which children that are under the age of 18, their monies will be held in trust, payable with interest when they turn 18. The question I have here, if Wilfred is not the chief, what happens? Can the new chief hire a different lawyer, or can he decide how negotiations continue? And would a change in counselors put the claim at risk?
Well, so the answer is if there's a new chief and counsel, and look, I mean, I'm just being descriptive here. If there's a new chief and counsel, since there's no signed deal yet, they could fire me, they could reject the deal, they could accept the deal, they could continue the case, they could hire a different lawyer, they could end the case. A new counsel can take a whole new direction if they choose to. And the reality is, until there's actually a signed and approved deal, everything is open to being changed. And so anything can happen with a new counsel.
There's no more questions, Robert, but I think one of the key things is that if you want to talk briefly about the right-of-way claim very briefly, and also the treaty annuity very briefly.
Okay, sure. So there's another claim that was rejected years ago, which the chief and counsel asked us to look at, and that was about how the highway was taken from your reserve. And you know, there's a recent Supreme Court of Canada case involving the Lac Seul First Nation, where there's some very favorable language in there. So we are presently looking at that claim again. The band and us, we've hired an economist who understands these issues. They're looking at whether or not there's more value in the land than you were compensated for back when the highway was taken. That's taking a bit of work, and it's something else that will be looked at once the chief and counsel, whoever they are once after the election, essentially. On the annuities case, you know, so in the annuities case, like obviously for the Robinson Superior annuities, it was White Sand and Red Rock doing the case. You know, and they won the first part of the case, which said that there's supposed to be an adjustment to the annuities. They won the second part of the case, which says that there are no limitation periods. Those parts have been appealed, and the Court of Appeal is considering them, but I watched the appeals and they went very well. So now it's going to court around, and this is in May, around the whole issue of how much money and how should it be divided. and I've been working with the chief and counsel and then with the lawyers for Red Rock and White Sand to try to figure out the best approach to this. So, because there's, the plan that Gull Bay and the plaintiffs agree with is essentially that the annuities should be, that they should focus on making the annuities the damages as big as possible, increasing the annuity as much as possible, and that the division should be based on population at the time of judgment, which is about 2.5 years ago. There's other bands that are taking other positions, and there's a lot of jockeying around that. There's going to be, we have to file with the court before November 15th to be given the right to join in the case to argue for that kind of split and to help support Red Rock and White Sand and to make sure that the Gull Bay and its members get their share of the overall annuity. So that case is ongoing and is very busy. There's a lot of stuff happening, and we're keeping on top of it to make sure that Gull Bay gets its fair share, as do the Gull Bay members.
There was one final question on ODSP and Ontario Works. They will not be affected by the settlement. It's considered settlement money, so your ODSP or OW will not be taken away from you. In 2 weeks' time, everybody, I want to thank Robert for taking time out tonight to speak to the members. Unfortunately, we didn't get a chance to have him in person because of COVID. In 2 weeks' time, we're going to have our other lawyer, Etienne Escueda, joining us, and he will give us an update on the flooding claim. That's another very, very significant claim that we're currently negotiating. We feel that there's going to be a settlement coming on that one as well. Etienne will explain the flooding claim to everybody and why that claim is so important. So I want to thank you all again. These claims are very important. Also, that on October 20th, there's going to be an all candidates virtual meeting starting at 6:30. So on October 20th, an all candidates virtual meeting. So I'd like everybody to tune in. And that's all the time we have for questions. I'm sorry, and try to answer all of the important questions that were relevant to the land claim. So I want to thank you all for joining, and make sure to join us in 2 weeks' time when Etienne Escueda, our lawyer, and myself will be talking about the flooding claim. I want to thank you all. Chimiquich for everything.
Yes, and can I just say, I hope I get to see you all during a ratification vote in the early winter. So I'm hoping I'll be able to get up there by then, and all this pandemic will be in the past.